For the state. Ladies and gentlemen of the jury, good afternoon. I feel like everybody in this courtroom continues to get up here and promise you that we are nearing the end. We're in the home stretch. We are almost done. We promise it won't be much longer. And I'm actually going to stand up here and say exactly the same thing. But truly, we are in the home stretch. What you are doing is incredibly noble, but fatiguing and grueling work. And it is critical to our system of justice, so for that we thank you. This is truly the most important day in the life of Kentrevious Garard. So please just bear with us for a little bit longer. You've paid careful attention and I've watched you take careful notes, and so stick with me for just a minute. I promise to be respectful of your time. But for your careful attention, Mr. Garard thanks you, and I certainly thank you. My name is Attorney Nicole Jameson. Kentrevious Garard is my client. He is a brother. He is a son. He is a grandson. He is a lifelong resident of Duval County, Florida, a hard worker since the age of 16, human being, a young man so softly spoken that he waited 2.5 years to tell his own legal team that we were mispronouncing his name, and he is not guilty. He is a chooser of bad friends. We talked a little bit in jury selection about individual responsibility. Now, the military is kind of a perfect example of this notion of collective responsibility. And for those of you that don't have any sort of personal experience with it, I'm sure we've all seen it on movies, right? Stripes, for instance. Bill Murray is the classic smart aleck who can't keep his mouth shut, and as a result, the entire platoon gets punished for his antics and bad behavior. Well, the military, there's actually a reason for that, right? Kind of the suffering of the collective actually encourages brotherhood and cohesiveness. It encourages leadership, right? Because the idea is that somebody will become a leader and speak up and stop that bad behavior so the entirety of the collective doesn't suffer anymore. The criminal justice system is not the place for collective responsibility. We see collective responsibility as parents, right? Especially mothers to boys. You hear shenanigans in a back bedroom, you walk in there, there's a broken lamp, and 2 of your sons are in there. You don't bother to sort out who's responsible for it. You cut corners, you punish both of them, you send them to bed, or you take away their video games, etc. Why do we do that? Well, we do it because we as parents are tired, right?
You can proceed. It's just the buzzer in here is very loud. Ms. James will let me know what it's about.
We're tired. We don't have time to sort out their shenanigans. They probably were both responsible. And cutting corners as a parent is okay, because the nature of the consequences is the loss of TV or the loss of a PlayStation, right? The loss of a privilege. It is not the loss of forever liberty like that which is at stake in a criminal courtroom. We don't cut those kinds of corners in a criminal courtroom. As parents, it's easier to punish collectively, and if we make a mistake, it's okay. It's forgotten the next day. Sometimes we apologize for it, sometimes we don't. That is simply not sufficient for a criminal courtroom. A criminal courtroom is no place for collective punishment. Evidence is necessary. Today, a man's life hangs in the balance, and as such, the highest burden under the law is required. There is absolutely no room for error. In jury selection, we talked a little bit about this. We talked about the dangers of guilt by association. Juror number 49 had actually been in a car when that car was stopped by police and the driver was actually shot. She admittedly chose a bad friend. We talked about that in jury selection. She said she did not even have any idea that the vehicle she was in was stolen. Perhaps her parents warned her to stay away from that friend and she didn't listen. But under guilt by association, she would be convicted of that crime. And we do not do that here in this courtroom. A bad friend choice is not enough. Even presence while a crime was committed is not enough. The judge will actually tell you that in your jury instructions, and I'll circle back to that in a minute. Mere knowledge that a crime has been committed, not enough. The law does not require you to report a crime that you know about. And again, the judge will tell you that as well. I will read that jury instruction to you. He has actually already told you that. You will have those jury instructions back in the room with you when you deliberate. The law does not require you to be a snitch. The wickedness of the wicked shall be upon himself. Ezekiel chapter 18, verse 20. And that in and of itself is the notion of individual responsibility, and that is what our criminal justice system is built upon. You should not concern yourself about the criminal actions of Marcel Johnson. They have absolutely nothing to do with your purpose in this courtroom. While the trials were conducted at the same time, his jury will exact their own justice against him. And that has nothing to do with my client, Kentrevious Garard. A bad friend choice does not equate to evidence. In this criminal courtroom, the state has the highest burden under the law, and that is beyond and to the exclusion of every single reasonable doubt. They must prove that by way of evidence that you can rely upon, and that evidence must convince you beyond and to the exclusion of every single reasonable doubt. Going back to individual responsibility, the jury instructions that you heard, which must feel like a very long time ago, were as follows. The defendants have been tried together. However, the charges against each defendant and the evidence applicable to him must be considered separately. The guilt of Marcel Johnson has absolutely nothing to do with the guilt or innocence of Kentrevious Garard in our trial. Whether or not you feel Marcel Johnson is guilty of these crimes should not influence your verdict against Kentrevious Garard. That is in the instructions that the judge read to you a very long time ago. You will have them back in the jury room. You must independently determine whether the state has proven their allegations against Mr. Garard beyond and through the exclusion of every single reasonable doubt by way of evidence that is reliable enough to support a verdict of guilt in a murder trial for which a man's life hangs in the balance. What is not evidence? Gut feelings, hunches, maybes, might haves, those things are not a substitute for evidence. In jury selection, we all agreed that if you think maybe he was involved, but the state did not prove his guilt beyond and to the exclusion of every single reasonable doubt with reliable evidence, the law mandates that your verdict be not guilty. We do not have to prove Kentrevious Garard's innocence. That is not how this process works. Likewise, we chose you because in jury selection, you committed that you were capable of that surgical, steady-handed approach. You confirmed the importance of not substituting emotions or sadness for evidence. Let's be clear, what happened in this case was an unspeakable tragedy. The injuries inflicted upon young Mr. Holland, Talent Walker, and Jalen Burrows were horrific. They were inexcusable. Nobody in this courtroom would deny that. Not myself, not Mr. Garard. But we're not here today to make statements through a verdict about tragedy. All promised that in jury selection. That is not our purpose today. Mr. Garard is not responsible for that tragedy. He has entered a plea of not guilty, and he has asserted his innocence through every single solitary step of this process. Ladies and gentlemen, there is not one single solitary shred of physical evidence that suggests Kentrevious Garard did anything other than make a bad friend choice. There is not one single solitary shred of physical evidence that ties him to a homicide or the crimes of attempted murder. In this case, law enforcement developed a narrative. They tried to make innocent pieces of information fit into that narrative, and then they stayed quiet about those innocent pieces when they didn't fit the narrative. I think that industry term is tunnel vision. That law enforcement officer who was a detective at the time of this crime and shortly thereafter promoted to sergeant. Remember, my client's arrest was in February of 2023. He was promoted to sergeant shortly thereafter in 2024 after making an arrest for JSO in a high-profile case, despite what we all heard in this courtroom about the investigation. And if you think he's not invested in seeing his tunnel vision to conclusion, if you think he is not justifying his incomplete investigation, well, look over there in the galley and you will see him sitting in this courtroom even right now, his testimony long having been over. What did not fit the narrative? I'm going to circle back to some of these things again later, but namely, the DNA, Mr. Garard's cell phone records, Amila Karanyaga, his then at the time girlfriend, the lack of absolutely any single solitary shred of evidence in his social media to show that he even knew who these people were, that he even knew the individuals. Not one shred. The state of Florida had 26,000 pages of his social media records. The detective admitted, yes, shows deletions. And ladies and gentlemen, you can better believe that if there was anything in those records that showed he had deleted something, a comment on Mr. Burrows' social media, a comment on Mr. Marquise Holloway's social media, any chats, any discussions about this, you can better believe they would be up in living color on these screens. They are not, because they did not exist. Not just that. No proof, not one single solitary shred of proof that he even knew them. You heard his testimony. I had never seen Mr. Burrows before in my life until he walked into this courtroom, and nobody, not one single witness or not one single piece of evidence contradicts that. Did not even know what they looked like. Didn't know anything about what vehicle they drove. What else didn't fit the narrative? Well, simple things. The fact that Mr. Garard was actually a working man at the time of his arrest. If you'll recall, now Sergeant Mittling's own testimony, well, I can't say whether he was arrested on his job or not. And then when further pressed, well, okay, I guess he was in a vest. It looked like a work vest and maybe wearing some kind of a hat. Why? Because they don't even want to admit that he is an individual who is employed, who has a job. What else did they ignore? Well, the fact that he was visiting his family in Georgia. Asked Detective Mitling, his presence in Georgia certainly looked guilty to you, right? Yes. Yes, in fact, it did. Did you even pick up the phone? I'm not even asking that you drive up to Georgia. Did you even pick up the phone and call a single solitary family member? Was he there? When did he get there? Was it planned? Is this something he does all the time? No, absolutely not. Why? Because it doesn't fit into their narrative that he had committed this crime. What else did they ignore that didn't fit into their narrative? Well, briefly, the vehicle descriptions, that it was the shooter vehicle was different than a blue car. From the actual witnesses on scene who witnessed the shooting, supported by the surveillance evidence in the case. We'll get back to that later. Jawan Thomas, ladies and gentlemen. Jawan Thomas, an individual who took responsibility for a homicide 30 minutes after it happened. 30 minutes. How would he even know that a homicide had occurred 30 minutes later unless he's the one that did it or was somehow involved? This hadn't been broadcast to the news at that period of time. It wasn't public knowledge. 30 minutes. Posted, if you think I did it, I did it. Post not even preserved for you to look at, to interpret what it meant. And then guess what? When they got his social media, it was missing to suggest it had been deleted. The state is going to stand up here and suggest to you that the Jacksonville Sheriff's Office investigated Jawan Thomas. They did the best that they could. They did not even talk to him. And the explanation for that was, well, we can't just go dragging people in. Oh, absolutely they can, and they do it all the time. You think they need an arrest warrant to bring you down and ask you to talk to them? Absolutely not. You think they need an arrest warrant to go to your house and interrogate you? Absolutely not. Did not even talk to him. Oh, well, we searched to see if he had access to a blue car. Did not interview a single solitary one of his family members. Not one. Where was he on that day? Where was he at that time? What was he doing? Does he have access to his Estava-style rifle? Who knows? Because the questions were never asked. It is a mystery, and mystery by its very definition is reasonable doubt. Jacob Olds, Kendall Brown, occupant of Jacob Olds' vehicle, did not even speak to him, did not even talk to him. What else didn't fit their narrative? Descriptions from witnesses at the actual scene. 2 cars appearing to be acting in concert with each other filled with occupants. Ignore that. Not important. Don't pay attention to what's over here. Vehicle descriptions. White Charger, dark Dodge. This is why, ladies and gentlemen, it is so crucial to have trials. This is why you, as jurors, are so important. We talked about the awesome power of the government to pluck a citizen from his ordinary life and subject him to a permanent deprivation of liberty, and you alone are the only check on that power. The only check. Because you have seen what happens when law enforcement jumps to a conclusion and does not do a thorough investigation unfold before your eyes. You, as individuals and, a collective body, are the sole determiner of the facts in this case. Not Sergeant Mitling, not Mr. Powell, not Mr. Grau. They stand up here and tell you what the facts are. Sergeant Mittling stood up here and narrated a grainy surveillance video for you. And it's been done repeatedly to tell you what it shows. Well, the blue car is doing this and the white car is doing that. And, this is the position of the vehicles and this is where the shots came out from. Not using any kind of tools or technology beyond his naked eyes, you get to say what that video showed. And you alone. You get to watch it. Your eyes are no different than his eyes. He does not get to tell you what that video shows. You watch it. You decide for yourself. He is not an expert witness. He is not a forensic crime scene reconstructionist. You have heard not one single solitary shred of testimony to support the state's suggestions of this is how the shooting happened. This is where the shots came from. You have heard not one single bit of expert testimony to support that theory. It is simply a theory, and a theory alone that fits their narrative, ignoring all other evidence in the case. The prosecutors are echoing that theory. They are presupposing that the shots occur after the white Charger moves on surveillance video at the intersection in front of the red Mercedes. Presupposing that that happens despite no evidence to support that assertion. Ladies and gentlemen, there is but one muzzle flash captured in that video surveillance. There are 22 shots. Do you think the shots started before the vehicles come into view of that particular surveillance angle? Absolutely, I suggest to you that that is consistent with the fact that you only see one muzzle flash and there are 22 shots. Remember, this assumption that it's the blue vehicle is simply that. There are no identifying characteristics about that vehicle. There's nothing unique about it beyond the way it appears straight off of the manufacturer's factory belt. Okay, nothing unique. There's no modifications. It doesn't have rims. It doesn't have any damage to it. It is no different than any other blue small sedan, and I submit to you, I do not think they can even affirmatively assert that it's a Kia Rio. There's no license plate, there's no VIN number. But when questioned about whether or not the white Charger and the gray sedan, also seen in each and every single one of those video surveillance frames, are consistent from frame to frame, well, I can't tell you that. I have no idea. I can only make those conclusions about the vehicle that supports my arrest and my theory of prosecution. Can't weigh into those other vehicles. The vehicles, which, by the way, match the descriptions of witnesses from young Mr. Walker, who was actually in the red Mercedes itself, said, I saw an unusual dark in color sedan parked across the street before we even left. And I saw the same dark in color sedan fleeing the scene after the shots. But ignore what he says, because it does not support their theory. Not one person talked to anybody or even investigated a dark in color sedan. You'll have the video surveillance in the jury room. You can watch the behavior of that dark in color sedan as the red Mercedes is first captured on video. It is incredibly unusual. And the state's explanation for that is, oh, well, there was an ambulance pulling out. Well, then you wait. You don't pull out to ensure that you stay on pace with a red Mercedes in the wrong lane of travel. You stop and wait. That dark in color sedan did not do that. It ensured that its direction of travel kept pace with the red Mercedes. Incredibly unusual, and in violation of traffic laws. The facts are what you determine them to be, and you alone. We've talked a lot about reasonable doubt. Where does reasonable doubt come from? Well, first I would start by saying, remember that it just takes one single doubt that is reasonable, just one, and the law commands that your verdict be not guilty. And remember, it's something not often said, but in our criminal justice system, not guilty doesn't even necessarily equate to innocence. It means a failure to prove. It means a failure to sustain the government's burden, which is the highest under the law. But luckily, in this case, Mr. Kentrevious Garard is factually innocent, and the only just verdict is not guilty. Well, what is reasonable doubt? Ladies and gentlemen, it's whatever you as jurors determine it to be. You get to decide that. The law is instructive. The judge told you earlier, a verdict of guilty requires an abiding conviction of guilt. Or, if you have a conviction, but it's one that's not stable, but it wavers and it vacillates, then the charge is not proven by every reasonable doubt. Every single reasonable doubt. Then you must find the defendant not guilty, because the doubt is reasonable. You get to decide what is a reasonable doubt. You and you alone. And there is plenty to pick from in this case. The judge will tell you where it can come from as a sort of guiding principle. Well, it can come from the evidence itself. It can come from the conflicts in the evidence, and it can come from a lack of evidence. I'm going to talk to you briefly just about each one of those categories to help give you a roadmap to all of the reasonable doubt in this case. And remember, if you have just one single doubt that is reasonable, the law commands a not guilty verdict. I'm not going to review everything. You guys have been sitting in this trial just like us, listening carefully and taking diligent notes, but this is truly critically important. So it's essential that I highlight a few things. Let's talk about the evidence itself. Well, in this case, there just simply is none that supports a verdict of guilty. I want to talk to you briefly about Kobe Johnson and Emmanuel Pringle, admitted liars. And the issue with that is that because they have admitted to lying in one statement, you cannot believe any statement. That is the issue. You cannot and should not sort out what is the truth, and you, as jurors in this case, are permitted to disregard anything that they say, everything that they say. The judge told you that during your instructions. You can believe all of what a witness says, some of what a witness says, or just disregard it entirely. That is the awesome power that you have, and I suggest to you that that is what you should do with their testimony. Why? Mr. Powell tried to talk about this. Why? Why would they make these statements implicating Kentrevious Garard? Well, he is sitting right behind Mr. Garard. That is the reason why they made those statements. Why would they implicate Mr. Garard? Well, because their friend, Marcel Johnson's life hangs in balance, and Kobe Johnson is his own biological brother. His quote on the stand, "I am my brother's biggest fan," admitted that he knows and understands if his brother is convicted, he will never leave prison again. Never. That is why he is lying. You must remember, not one single solitary thing that he said implicated his brother. Not one. And the state's theory is that his brother was the driver and involved. That doesn't make sense. How are you to believe part of what he says but just disregard that part? Most importantly, with respect to Kobe Johnson and Emmanuel Pringle, their testimony is inconsistent with the other evidence in the case. The state said with respect to Mr. Johnson, well, it's not unusual for people to lie to the police. He didn't want to be a snitch. Well, ladies and gentlemen, that's exactly what Mr. Garard told you when he took the stand. Yes, I lied to the police. I did not want to be a snitch. but believe the brother of the man who did this and not Mr. Garard. I want to talk to you about this additional detail that Mr. Johnson gives. Mr. Kobe Johnson, to be clear. I'm sorry that gets confusing. Mr. Kobe Johnson has given a number of different statements in this case. His first interview is December of 2022, during which he just admits he completely lies throughout the context of the entire interview. Does not tell one single solitary shred of truth. He then, on probation, facing up to 6 years in prison, is compelled to come back down and give another statement. And at the time of being forced to come back down and give another statement, he is performing, okay? He's got the detective there, he's got the prosecutor there, and he is on probation. And he adds this extra detail that never appears anywhere else, ever. Never. This juicy detail that is horrific. That supposedly my client said that he saw this young man's head hit the window. That is horrific, and it is completely inconsistent with the physical evidence in this case. You have pictures of this SUV, okay? You have the surveillance video that show the seconds during which this happened. Look at the windows on this SUV. That doesn't even make sense. They are tinted so dark you can't even see through them. That extra bit of information makes no sense. His statement is inconsistent with the physical evidence in this case. The state keeps suggesting that, well, Mr. Johnson and Mr. Pringle both give this consistent statement about spraying up a car, and Kobe Johnson wouldn't even know about that in January because Mr. Pringle wasn't interviewed yet. He absolutely was. He was interviewed multiple times. He was interviewed in December of 2022 for the first time. Why, the state keeps saying, why pick Mr. Garard to blame? Well, because they all knew that their friend, fellow companion in a group that references themselves as 320, Marcel Johnson, was at my client's house the day this happened. Let me please remind you, during Mr. Powell's presentation of motive, right? Why Mr. Garard somehow has motive. Well, because of all this horrific violence going back and forth between people, not one single solitary bit of that involves him. You have not heard one single witness suggest that he is a part of anyone that references themselves as 320. Who is Kobe Johnson, Marcel Johnson, Emmanuel Pringle, and his brother, Isaiah Pringle, a.k.a. Zay. Who has motive in this case? Who? We're going to talk about that some more in a minute. Now remember, at the time Mr. Pringle came in here and testified, he is actively on probation, lied to the police in violation of that probation, recommended that he be sentenced to incarceration, and just, by the way, thanks for your giving us what we wanted in this criminal case, you're free to go back on probation. Back out in the community, walking amongst us. Mr. Powell, during his presentation, discussed what would be their motive for lying. Well, ladies and gentlemen, we don't have to give you one. We have no burden to prove a single solitary thing. Not motive, not who did this, not how it was done. But lack of motive is certainly a place from which you as a juror can find reasonable doubt. Lack of motive equals a reasonable doubt. And remember, with just one, the law commands a verdict of not guilty. I want to talk to you about who has the motive in this. In 2019, Marcel Johnson. In 2019, the brother of the state's witness, Emmanuel Pringle, Isaiah was shot in the head and injured so severely during high school. And remember, who went to high school together? Not my client. He had nothing to do with that. Didn't even know these people. Who went to high school together? This dispute, this beef, this streak of retaliatory violence dates back to high school, having nothing to do with Kentrevious Garard. Who was fighting back in high school? What started as schoolyard fights escalated to a string of horrific gun violence, none of which has anything to do with my. During the state's presentation on motive, they talked to you about all these awful things, all these murders. Not one single solitary shred of evidence suggests that he was involved or had any reason to have a disagreement with these people. Who did? Marcel Johnson, Kobe Johnson, Emmanuel Pringle, Isaiah Pringle. They did. Marcel Johnson was the ringleader. He is older than his brother. Kobe Johnson is his brother's biggest fan. He is a brother who exacted revenge on behalf of Kobe because he couldn't handle a schoolyard fistfight. And let's be honest, that's what it was just 2 months before this happened. End of September 2022. There was an incident having nothing to do with Kentrevious Garard. He wasn't there. He had nothing to do with that. Kobe Johnson and Marcel Johnson are the only ones that involved. Jalen Burroughs and his brother Marquise Holloway. Jalen Burroughs was a coach at a charity event at a car wash next to an O'Reilly's. And that charity event was to raise money for Kobe Johnson's belief is that Jalen Burroughs saw him, picked up the phone, called his brother and a bunch of his brother's friends to come up and surround him, basically ambush him. And it was, I can't remember if they said 5 or 6 against 1. You guys can use your own recollection. And he was beat up. You see the pictures. They're in evidence. Where did those pictures come from? Marcel Johnson's phone. Not Kentrevious Garard's phone. There's absolutely not one single solitary shred of evidence that those pictures were sent to my. Not one. He was not present. They did not involve him. The state offered this motive with respect to, I guess that's what it was offered for, but there was some comment from Mr. Burroughs himself on the stand that's never before been heard. He was asked extensively about this stuff during depositions, and it was something to the effect of, oh, well, one time I saw that your client made a diss comment or a mean comment on my brother's social media. Ladies and gentlemen, Sergeant Mittling on the stand acknowledged 6,000 pages of social media records. Not one shred of support for that assertion in the records because it did not happen. It is the best that they could do. Well, one time back in 2020, he made this comment. My client does not even know Jalen or Marquise Holloway. Both Kobe Johnson and Emmanuel Pringle acknowledged that their friend Marcel was the reason behind all of this strife to begin with. Both acknowledged he was facing life in prison, never to be seen again. Not believing a witness is reasonable doubt. And let's talk about the murder weapon. This is Marcel Johnson and Kobe Johnson's gun. It was purchased by Kobe Johnson in 2022. Not one single solitary shred of evidence that my client has ever owned such a thing, ever. All facts that everybody forgets to admit to law enforcement. Why would they lie? I'll tell you why they lie. They're protecting Marcel Johnson. That Zastava-style rifle that Mr. Kobe Johnson says he just never saw again was posted by his brother 4 days before the homicide. Shortly after he was beat up, not by Mr. Garard. Absolutely not. And please remember, it was not discussed very frequently, but there is another 5.56 casing that is found at a shot spotter scene 10 months after my client was in jail. That gun is still out there, and I submit to you, perhaps so is the shooter. That is not our job to solve that mystery for you. The fact that it remains a mystery is by its very definition reasonable doubt. Lack of motive equals lack of evidence equals reasonable doubt equals not guilty. I want to talk to you a little bit about Mr. Garard. Cloaked in innocence, and that presumption of innocence remains with him throughout every single material stage of the trial. Further, he has a very powerful constitutionally bestowed right. It's the right to remain silent. He does not have to prove his innocence. I don't have to prove his innocence. Not in this courtroom, not in any courtroom in this country. He set aside his constitutional right to remain silent. He didn't have to speak to detectives in this case. He knew he had a right to a lawyer. He had already discussed it with his family and planned to get one. He set that aside, he talked to detectives, and he asserted his innocence. He told them where he was. He explained the things they were confronting him with that they thought made him look guilty. And they did not look into a single solitary one of them. He volunteered phone numbers, his social media accounts. Now, the state mentioned something about cell phones. We had several cell phones. Is having multiple cell phones something you and I would perhaps do? Maybe not. Maybe so. It's not proof that you committed a murder. Some of us have the socioeconomic advantage to go down to Verizon, have our credit checked, sign a contract, pay $2,000 for the latest and greatest iPhone, and get upgrades on the regular. Some of us do not. Some of us have Straight Talk, Text Now. Some of us may have not even ever heard of those things. One of those phones was an iPhone 7, ladies and gentlemen, an iPhone 7. I can't tell you how many years ago that was, but I think we're on a 16 or a 17 at this juncture, okay? That's how old that phone was. Not everyone has the socioeconomic privilege of discarding a phone once it's broken or replacing it with the latest and greatest. There's no proof from the government of where the phones were purchased, who owned them, what the subscriber information was, and 2 of them weren't even activated. So what? Is it weird? Maybe. Weird is not evidence of a murder. It's not proof of anything in this case. Well, he deleted a search about a SIM card. Those are the actions of a man who is scared of the police upon learning that the police raided his mother's house for reasons he did not understand at the time while his 9-year-old brother was there. A man who had never before been interviewed by the police, scared of the police, taught growing up not to volunteer yourself to the police, do not speak with them, do not snitch. He didn't even want to tell you in this courtroom that Marcel Johnson sold marijuana, but he did, reluctantly. Mr. Garard told the police where he was. He told them who could vouch for where he was, and they said, "You're lying." They referred to him as a black boy in Folkestone, a working man who had no prior record then at the time of his interview, 25 years of age. On his job at the time of his arrest, he said, "My girlfriend can vouch for where I was. She's lying. Your cell phones are lying. Your social media is lying. Your DNA is lying." The lack of any relevant evidence in his home, according to the prosecution, irrelevant. Not even in the report. The lack of any proof of a motive, irrelevant. Don't pay attention to that, would be the state's assertions. Lack of any proof of prior conflict, disregard. Lack of a Zastava-style rifle purchased, possessed, ever displayed. Yes, there is one photo in an entire batch of extracted cell data that occupies discs upon disc upon disc from March of 22 that is absolutely taken by Marcel Johnson. How do we know that? Because it is the exact hat he was wearing and at the exact time that he makes that Triller post video. Remember that post. Marcel Johnson dancing around his apartment, having nothing to do with my client, waving the murder weapon around in this case. On cross-examination, they said, "We can't tell you that he took that photo. We can't tell you where it came from." Mr. Powell said, in his interview, he, quote, lied multiple times to protect himself. Ladies and gentlemen, that is absolutely not who he was protecting. Marcel's motive, Marcel's gun, Marcel's strife, Marcel's gunshot wound, Marcel's blue vehicle. Mr. Garard told the police, "Not only was I with my girlfriend, we went that afternoon to get juicy crab. Did not even go down there." The state would suggest, "Oh, well, that's irrelevant because it happened earlier in the day," but did it really? But for the work of the defense to produce the receipt and the post, you wouldn't even know. It is the state's job to seek the truth and to seek justice and not just to present the evidence that supports their theories. Not irrelevant. You know why? Because the proof of having gone there and the times that they went there absolutely corroborates where he told the detectives he was and what he did that day. "I went to Juicy Crab way over on Blanding with my then girlfriend, Amila. The receipt shows a time of approximately 2:08, way over on Blanding. What time did you get back to your house? Well, he told you, this is a long time ago. I'm only estimating. I can't be very specific, but I can give you estimates, and those estimates are supported by the 2 documents that the defense had to go get. Social media posts showing them at his dining room table eating a seafood spread at 4:25 p.m. in the afternoon. The state would have you believe that that's irrelevant. Why? Well, because it doesn't support their theory. Why is it important? He is spending the weekend with his girlfriend. Does it make sense to you that they wake up, they go to Juicy Crab, they come back, they eat a seafood feast that lasted until Well, the post was at 4:25 and they were still eating. Clean up afterwards. It lasted until sometime after 5 o'clock, and by the way, just left, went and committed a murder and came back. Absolutely not. That is the most absurd thing I've ever heard. One of the things that the judge told you earlier, in terms of judging the credibility of a witness, you have some tools. You can use your common sense, of course, but in the jury instructions, it will say, was a witness honest and straightforward in answering the attorney's questions? Mr. Garard, on the stand, never testified before, has never been interviewed by the police before, not a public speaker, not a professional witness, so soft-spoken, I had to repeatedly ask him to lean into the microphone. The man who let people for 2.5 years mispronounce his name. He answered each and every question. He wasn't evasive. He admitted on the stand to lying to the police and explained why. Scared, did not want to be a snitch, did not want to implicate his friend by admitting he recognized that car. The state would try to suggest, well, this thing about Mr. Johnson and him growing distant, that's not believable because they still, had phone communication and hung out. He told you that. He said, look, we didn't have any kind of big blow up. There wasn't a big fight. I just started to not agree with or approve of the things that he was doing, so we weren't as close anymore. We still talked. We still hung out. He still came to my mom's house to smoke weed outside and play video games. I bought my weed from him. He did not avoid my questions. He said on the stand, much to my absolute embarrassment, because I asked a poorly crafted question, what did you do with your girlfriend when you first got there? Told everybody in this courtroom, well, we had sex. That's not what I expected him to say, but it was absolutely responsive to my bad question. He did not argue with the state attorney's office. He's not a professional witness. Nervous over the magnitude of what is at stake, certainly understandable. Versus, let's talk about professional witnesses in this case. Agent Blythe. He is with the FBI. He testifies all the time. He's testified hundreds of times. He testifies for a living. It is his job. Was Agent Blythe honest and straightforward in answering the attorney's questions? What should have been 15 minutes of questions took over an hour because he could not answer a simple yes or no question. And maybe it was me. Maybe I was off that day, but I feel like I do a pretty good job of only giving a yes or no option. Well, no, but 15 minutes of explanation to circle back around to the state's theories. We would do that 2 and 3 times. So Agent Blythe, what it sounds like you are saying is that your answer was no. Well, no, but 15 minutes of explanation. And then I would just have to again. So what you're saying is that your answer was no? Over and over and over again, to the suffering of everyone in this courtroom. The entire point of my questions for Agent Blythe were to illustrate that Mr. Garard's phone was at his house at the time of the crime, which is consistent with every single statement he has ever given. He was home at the time of the crime. And even though Agent Blythe picked and chose which data to include on his presentation, admitting finally, after I had to go over there repeatedly, that he didn't include all of the data from the 2,400 or so lines of a spreadsheet, the activity that he himself notes on his own report shows data happening at 6:15 p.m. from Mr. Garard's phone while Mr. Garard is at his house. Why is that time period important? Ladies and gentlemen, on that surveillance compilation, you will see, and the state pointed it out during their presentation of evidence, that blue Kia is parked across from the Legend Center at 6:15 p.m. The time that Mr. Garard is on his phone at his house. It is physically impossible for him to be in that blue car. Physically impossible. It is inconsistent with the cell phone data in this case. Mr. Powell said something during his first close a moment ago. Well, you would expect to see calls and texts during that time. Look at Mr. Garard's T-Mobile records. He's not a caller or a texter. There are very brief calls and texts. Young people use all kinds of other means on the phone to communicate. Social media apps, FaceTime, etc. Calling and texting is a bit dated. And you will see that is consistent in Mr. Garard's T-Mobile records. He just doesn't do a lot of calling and texting. They postured all kinds of hypothetical theories on how that could be explained. And ladies and gentlemen, that's all they are. They're hypotheticals and guesses that are not supported by evidence because the evidence doesn't support their theory of prosecution, so they are trying to explain it away. This is the state of Florida's burden and their burden alone. They have not shown you a single solitary shred of evidence that Mr. Garard was anywhere other than where he said he was at 9210 7th Street, and their failure to do so is magnificent reasonable doubt in this case. One reasonable doubt commands a not guilty verdict. There's absolutely not a single shred of evidence that he was not at his house with his girlfriend and his cell phone on December the 3rd, 2022 at 6:15 and at 6:21 p.m. until he left later that night to go buy marijuana in Brooklyn well after the homicide. Just a moment ago, Mr. Powell pulled up the timestamps and said, oh, well, he said he was at Brooklyn, and never got out of the car and just bought marijuana, rolled a joint, and was only there for a short period of time. That's exactly what the records show. It was 30 minutes. 30 minutes he's discussing a homicide and supposedly cleaning up a car? It's inconsistent with the state's own evidence in the case. Whose phone was in the vicinity of the scene at the time of the murder? Jawan Thomas, a suspect never even investigated. Pay no attention to that. It would not be of any evidentiary value. But somehow Mr. Garard's records are, which put him at his residence. Guess what else the phone records support? Well, they show him moving south at the time of his Juicy Crab purchase, which is consistent with where he says he was that afternoon and where his girlfriend says she was with him that afternoon. But that is irrelevant. It's not irrelevant. It's relevant because it's exactly consistent with what he told law enforcement, and law enforcement did nothing to investigate a single solitary thing that exonerated Mr. Garard in this case. Professional witnesses. Was a witness honest and straightforward in answering the attorney's questions? That is a place from which you can derive reasonable doubt. Jennifer Brown, the FDLE witness. It's been some time ago, but again, remember, it was like a replay of how my cross-examination with Agent Blythe went. Let's talk about the DNA swabs in this case. They were done in December 2022. That's when that car was processed. Guess when they were submitted for testing? January of 2025. More than 2.5 years of Mr. Garard sitting in jail. Did not even submit them until January of 2025. Mr. Garard was excluded as a contributor from every single sample which contained sufficient DNA that was taken from that blue car. Most importantly, from the front passenger seat, which is where in the state's theory he was seated at the time of this homicide, despite no evidence to support that theory. They say, well, that's irrelevant because he said he was in the car on Mr. Pringle's birthday. That's right, but he didn't say where in the car he was. The state's theory at the time of this shooting is that he was riding in the front passenger seat, a seat that is not leather, by the way, ladies and gentlemen. It is cloth, it is spongy, and it contained sufficient DNA for testing, and he was excluded as a contributor. Don't pay any attention to that. Pay attention to a fingerprint of unknown age on a door frame. A door frame that can easily be touched from the outside, by the way. I had to confront this analyst with each and every single sample over and over and over again, and she refused to say he was excluded until I had to read her direct quotes from her own written report. And I quote, "Kentrevious Garard is excluded as a contributor to this mixed DNA profile from item 8, which was the front passenger seat." And I had to do that for each and every single sample. Consider the print to be significant, but not the more scientifically reliable evidence of DNA, because it does not support their theory of prosecution, and that is a theme throughout this case. When it does not support their theory, a professional witness who testifies all the time is reluctant to give that information and is uncooperative with an attorney trying to get it. Now remember, conflicts in the evidence are a place from which you can get reasonable doubt. Detective Mittling, now Sergeant. From the scene and from the mouths of the witnesses who were actually there, the best evidence of who was responsible. Dark Dodge from the young man actually in the car. White Charger, 2 cars full of young adults or teens. From Miss Beeks, they appear, she was there in the intersection, appeared to be traveling together. Saw them moments later together at an entirely different location down Moncrief in front of her house, squealing their tires and driving recklessly. Jawan Thomas, if you think I did it, I did it. 30 minutes after the homicide. A failure to investigate all possible suspects is, by its very nature, reasonable doubt. Jacob Olds, Kendall Brown. And let's just be clear, we've talked so much about vehicles in this case, colors of vehicles, who the shooter vehicle was, what the surveillance showed. It's not the job of the defense to prove what car was involved, who was in the car, who was the shooter. That is the job of the government. The fact that everyone is still wondering is by very definition reasonable doubt. You can decide what the shooter car was. But again, even if you believe it to be a blue car, that has absolutely nothing to do with Kentrevious Garard, and it's not proof that he was even in that car. It is not proof that he was involved or responsible for committing a homicide, not one single solitary bit. I want to talk to you about the blue car, however, and I know everybody's sick of hearing about it. These pictures are in evidence. I'm going to pick this view of the car from the back. Been a very long time ago, but if you would remember, during my cross-examination of Wells, who was the evidence tech that processed this car, it's a small, in-size sedan. Very small. Yes, she agreed. In fact, it was. You didn't measure it, but would you have any reason to doubt me if I told you it was only 67 inches wide? No, I have no reason to doubt you. That sounds consistent with what I saw. 67 inches wide. I stand here before you, 5'3", maybe slightly more in heels, if I'm lucky, okay? 5'3". So I'm 63 inches, just, you turned me this other direction, just slightly smaller than the width of that vehicle. You have seen this gentleman, Marcel Johnson, come and go throughout this courtroom. You've seen him stand. Every time you enter, he stands 6'5", 77 inches tall with a wingspan of at least 77 inches or more. Longer than the entire width of that blue car. Why is that important? Power windows from the driver's seat operating the passenger side window. The state suggested through Sergeant Mittling, despite not being supported by any evidence whatsoever, it would take an expert marksman to drive and shoot. That is a style rifle. It is a pistol grip, ladies and gentlemen, and I suggest to you that unfortunately the outcome in this case dictates that we all know whoever was shooting was not an expert marksman. Jalen Burroughs was the target. Absolutely consistent with the physical evidence that Marcel Johnson is responsible solely for that shooting from the driver's seat of that blue vehicle. Why? Well, let's talk about this. You heard a lot about the presence of this mysterious GSR that cannot somehow be tested, despite the fact that FDLE used to do it. But what we heard from Wells is that there was indeed the presence of GSR on the interior headliner of that blue car. We don't have any pictures of it, unfortunately, because they elected not to take them. Why is GSR on the interior headliner consistent with a driver rolling down the window and shooting? Because GSR comes from the muzzle of a firearm, the barrel of the firearm. If the passenger was the shooter, let's consider that for a minute. If the passenger was the shooter, you would certainly see more than one muzzle flash for 22 casings, number one. If the passenger was the shooter, the firearm would be out of the window. You don't shoot holding a firearm from a passenger seat like this in front of you. No. If you are a passenger shooting, you extend that firearm out of a window, not leaving the presence of GSR, showing multiple muzzle flashes on video surveillance. That is not what happened, and that is not what the physical evidence shows. And again, for Mr. Garard's purposes, it is truly irrelevant. I'm not a detective. I'm not a prosecutor. It's not my job to solve whether it was the driver or the passenger who committed this shooting. Either scenario is irrelevant for Mr. Garard because he is neither one of those people. The fact that the question remains unanswered is in and of itself reasonable doubt. It's irrelevant also because there's not one single shred of evidence that Mr. Garard was anywhere other than in his house. Talk to you about this. A little bit more on the evidence itself. I promise I'm not going to torture you much longer, okay? The evidence that the state has for you is this. Look over here. Look over here at this YouTube video, not over here at the evidence that's been submitted. Look over here at this video. The date of this video is more than a year prior to the homicide. The state of Florida suggests, well, we had to show you that because it shows that they knew each other. That's not in dispute. Ask yourselves, what is the point? It is not evidence of anything. It was more than 16 months before this homicide. Mr. Garard is standing in the background, not saying a single solitary thing, not one word, not one lyric. Why do they show it to you? Well, because it shows a menacing young black man to distract you with emotion and fear. Whether or not you personally care for that kind of music is irrelevant. It's not evidence. And in fact, ladies and gentlemen, the United States Supreme Court has long held that artistic expression is constitutionally protected speech. It's constitutionally protected speech even if the lyrics are offensive. It's constitutionally protected speech even if the lyrics are violent and even if they are distasteful. It's fictional artistic expression, and it's no different than that of NWA, Johnny Cash, even Super Bowl performer Kendrick Lamar. Johnny Cash, okay? And that might surprise you. Let's talk a little bit about Johnny Cash for a second. Delia. And I met Delia here, found her in her parlor, and I tied her to a chair. Delia's gone. One more round. Delia's gone. She was low down and trifling, and she was cold and mean. Kind of evil, make me want to grab my submachine. Delia's gone. One more round. Delia's gone. The first time I shot her in the side. I had to watch her suffer. But with the second shot, she died. Delia's gone. One more round. Delia's gone. Equally violent, perhaps presented in a different, more folksy fashion. Words are the same. It's artistic expression, it's a distraction, it is not evidence. It makes you feel emotional about violence and sad about a tragic loss, and you should feel sad about a tragic loss, but your verdict is no place for that. You all promised that in jury selection. You all committed that you would be the surgeon in the operating room without that shaky hand. A few final, very more important rules, so to speak. And I'm sure you're more than tired of it, because all you have done during your service has been bossed around. Leave the courtroom. Don't leave the courtroom. Don't look at your phones. Don't watch the news. Don't talk to each other. Don't deliberate. But I promise these are crucially important. Mr. Garard does not have a burden to prove anything. Not his innocence, not who was in the car, not what car was used. He doesn't even have a burden to prove where he was, despite the fact that we have. It is the government with the absolute power to subject an innocent citizen to a deprivation of liberty, and it is their sole burden in this courtroom. If you get back to that jury room and you find yourself wondering what might have happened, what could have happened, that is another way of phrasing reasonable doubt. Common sense. This is something the state talks a lot about. They talk a lot about common sense. And ladies and gentlemen, while it's obvious that you do not check your common sense at the door, and that it is an important tool in evaluating evidence, it is not a substitute for evidence. The more the state discusses common sense, the more you should be alarmed, because it means they do not have actual evidence. On that note, is it common sense that a working man, no prior record, spending the weekend with his girlfriend, not involved in doing the things his friend was doing, who was intimate with his girlfriend as soon as she got into town, spent the day with her, went to go get juicy crab, eating a massive seafood spread at their house until probably after 5 p.m., left, ran out, committed a homicide, and attempted murders of people he did not even know, never met before, did not know what vehicle they drove, had no reason to have a single solitary disagreement with, no history of disagreements with. All because of someone he had known for just a couple of years? Absolutely not. That doesn't make sense. And it doesn't make sense because it didn't happen and there's no evidence that it did. We talked in jury selection briefly about individual verdicts. The law requires that you carefully and meaningfully deliberate by applying the facts to the law. There is absolutely no requirement that you change your own personal moral verdict. If you have carefully and thoughtfully deliberated and applied the facts to the law, and you are convinced that there is reasonable doubt in the case, then the law actually mandates that your verdict be not guilty. Nobody says you have to change your mind if other jurors disagree. There's nothing in the law that says you have to change your verdict if you're tired, if you're hungry, if you're tired of hearing from us, if you're exhausted with being here, or if you're bullied. In fact, that would not be a lawful verdict in this case. Now, the government gets the final word. Mr. Grau's going to get back up here and talk to you, and it's not for me or you to decide whether or not that's fair. It's just the way that it is. In light of that, I would urge you to consider, while he is talking, what Mr. Garard would have wanted me to say in response. What I would or could say if I had the last word on his behalf. And please remember, what the prosecutor says is not evidence. It is simply their arguments about the evidence. The law requires you to use your recollection of the testimony. I'm going to refer you to the Independent Act jury instruction. This is something the judge gave you a very long time ago, and in part it says, an independent act occurs when a person other than the defendant commits or attempts to commit a crime, which the defendant did not intend to occur, in which the defendant did not participate. That is exactly what happened in this case. The law states that if you find the homicide and attempted homicides occurred as a result of an independent act of another, Marcel Johnson, then you should find Kentrevious Garard not guilty. And finally, within that same instruction, mere knowledge that an offense is being committed is not the same as participation with criminal intent. Even mere presence at the scene of a crime is not enough to establish participation in the offense. Knowing that someone committed a crime is not a crime. It does not make you guilty of a murder or an attempted murder. The law does not impose upon anyone an obligation to snitch. It just simply doesn't. And while it might be morally offensive, it is not evidence. The jury instructions are admittedly confusing. There's a whole packet of them. They're written by lawyers, and I submit they're not ideal for understanding, but in this case, they don't even matter. As Mr. Powell suggested in his first opening, the only question is whether or not Mr. Kentrevious Garard did this. We don't dispute that a crime was committed. We don't dispute that it was a tragedy. We do not dispute that the crimes charged were committed against the people in that red car. Mr. Kentrevious Garard is not the person who committed them. He had absolutely nothing to do with that, and he is not guilty. The verdict forms are likewise confusing. You have to wade through a bunch of options on each count before you get to the not guilty section. We ask that you please wade through those, go to the not guilty section, and check a not guilty verdict as to each count and return Mr. Garard to his family. Thank you.